Welcome to our podcast, Decoding Gaming Law. I'm your host, Franklin, Head of Legal at Video Malta. And today we have another special guest, Dario Evangelista, Deputy General Counsel at Betsson Group. Dario, thank you so much for joining us today.
Thanks for inviting me.
My pleasure. And would you tell us a bit about you and what you do?
Of course. So I'm Dario Evangelista, the Deputy General Counsel at Betsson Group. I have been working at Betsson for almost 6 years. In total, in the gaming industry, almost 10 years. I'm a lawyer by profession. I started my legal career in a law firm in Rome, because I'm from Italy, from Rome. And then after these 4 years, in the, let's say, as a self-employed lawyer, I joined the gaming industry. And as I said, now in total, it's almost 10 years that I'm working in this industry.
Thank you very much for that, Dario. So today we're going to focus on mainly 2 important topics in the gaming industry: contract law, dispute and litigation.
Sure.
But before we move into that, just an initial question with respect to the regulatory changes. So what recent regulatory changes have had the biggest impact on the gaming industry?
So I would mention probably 3 main changes that have had a big impact on our industry. First of all, the introduction of gambling regulation itself, because in the recent years, we have seen many countries introducing a licensing, regime, giving the possibility to operators to apply for a local license. And obviously, the trend then has changed a lot in the past years, because obviously, if we see the gaming industry 10 years ago, 15 years ago, very few countries were regulated at that time. Instead, now it has become really a trend that countries are introducing their own licensing regime and regulated gambling and betting services. For instance, if we look at Europe, we can mention recent cases are, for example, Sweden, Germany. Next year will be the turn of Finland.
Yeah.
If instead, we want to refer to LATAM, we can mention the introduction of the licensing regime in Peru or Brazil.
Exactly.
Which happened, let's say, quite recently. So this, I would say that this is, in my opinion, one of the changes that is impacting the most, because obviously, this implies investing on compliance, investing on tools, investing on technology in order to meet local requirements and be able to apply and get a license and operate, let's say, in compliance with local laws in such regulated markets. Then, another changes that I would like to mention is the introduction of restrictions in advertising when it comes to gambling services. Because also here we have seen many changes in the past years, the introduction of many regulations going to reduce the possibility to advertise when it comes to gambling services, starting from the total ban that was introduced in Italy some years ago, then restrictions were introduced in Spain, more recently in the Netherlands and Belgium. So this is also, let's say, something that is impacting heavily on let's say, licensed operators. Also because sometimes, this is my personal opinion, no? Sometimes regulators want, or legislators want to introduce this kind of regulations in order to better protect players.
Responsible gaming.
When in my opinion, this has nothing to do with, let's say, giving the right protection to players. Because in this case, we are damaging, in any case, licensed operators, legal operators that invest a lot in compliance and the right tools in order to protect players, that have all the safeguards that are requested by law in order, let's say, to provide to players a safe environment. And sometimes we have seen that after the introduction of such restrictions, the percentage of illegal market has raised, and also the percentage of people with gambling problems has raised.
Yes.
So sometimes it's not the right approach that should be taken in order to tackle this kind of issues. And the last change that I would like to mention is regarding taxation. Not only in relation to the increase of gaming tax, across multiple jurisdictions. but also sometimes the introduction of new type of taxes that in any case are impacting a lot on let's say the financial projections and like the business of gambling companies. I mentioned before Peru as one of the countries that recently introduced a regulation. The regulation in Peru came into force in 2024, last year. Companies applied and got a license. And slight after, let's say, getting a license, starting operating in the Peruvian regulated market, a new tax was introduced, the selective consumption tax, besides the gaming tax, which in any case was not expected.
Yeah.
So like companies made investments, like knowing that a specific regulatory framework was going to apply, and then right after getting the license, a new tax was introduced, impacting a lot, obviously, like on the operations of gambling companies. Same goes for Colombia, where like as part of the emergency decrees introduced by the government from the beginning of this year, also a 19% VAT tax was introduced on gambling, on turnover, on gambling services. Also this, let's say, impacting, let's say, the operations of B2C companies in Colombia. So I would say that also taxation is an aspect like that we need to take into careful consideration, because changes introduced in this field may have a huge, heavy impact on the business.
In fact, we had a previous episode actually on international tax where we discussed the OECD's Pillar 2, and which was transposed into EU law as the Globe Directive. And, you know, it obviously has a massive impact not only on gaming operators, but across all other industries. Dario, I'm going to move on to the next topic, which is contract law. And it links, I think, a bit with player protection, in the sense, of course, when a player subscribes to a platform, there is a contract, there's terms and conditions. So the first question is, what are the most common type of contracts in the gaming industry that you experience with? And can you shed a bit of light as well as to the terms and conditions that players sign up to?
Okay, let's start then from the T's and C's that players needs to accept when registering, let's say, an account with a gambling operator. As you correctly said, this is a contract between, let's say, the operator and the player. And these T's and C's, in any case, are going to govern the relationship going forward after the opening of the gaming account between the player and the operator. That's why it is important also for players that they read carefully like the condition that will apply to their gaming account. And obviously like such T's and C's are going to cover multiple aspects of the relationship between the player. Obviously like in the T's and C's, players are made aware of, for example, which kind of payment options will be available to them, which kind of tools they can use in order, let's say, to control their gambling, no?
Yeah.
Which kind of measures that they can use in order, let's say, if they want to self-exclude, if they want to reduce, if they want to impose limits on their, let's say, on deposits, or let's say on for example on betting. So and also is going to govern, for example, the right to terminate the contractual relationship with the operator. It's also going to govern when, for example, the operator can suspend the gaming account and the activity of the player in case, for example, of if there is any suspicion of fraud or any illegal, I would say, behavior from the players. So that's why it is important to know, from a player perspective, which kind of rules are going to be applied by the operator when it comes to the activity performed on the gambling website.
And the T's and C's, can they be updated unilaterally, or must the player always consent and agree to any update?
So this also depends, in the sense that for sure, any update to the T's and C's are communicated, any updates are communicated to players so that they are always informed that something has been changed to the T's and C's. Then we need to understand, first of all, which kind of change the operator is going to introduce, because some changes can have like a huge impact on the relationship. And also from a consumer law, let's say, a perspective, sometimes there is the need like for a player like to reaccept, but it depends like on the type of change. If it's just like a cosmetic change, or in any case a formal change, or if it's something that is going to substantially like impact the contractual relationship. And then, so I would say that like is something that we always we take an ad hoc approach, depending, let's say, on the type of change. But for sure, in any case, players are always informed when like T's and C's are updated. So,
and when it comes to jurisdictional clauses governing law of the contract, or court or arbitration, what is, in your opinion, the most important jurisdiction, or sort of what is your jurisdiction of choice when it comes to that clause?
Okay, now, before I can even mention something really quickly regarding, let's say, still the relationship with like the players, and then I move like to proper contracts with, let's say, third parties, Because, for example, especially like in civil law systems, consumer law applies, And when it comes, for example, like operators can be based anywhere, For example, here in Malta or somewhere else. But when offering, let's say, services in another jurisdiction, from a consumer law protection, let's say, perspective, consumer has always the right to obviously like sue the operator in like the country of its residence. That's why like in the T's and C's, like the country of like the forum, the place of jurisdiction is always like the place where the customer is based. Speaking obviously about licensed operations. But now moving to contracts with third parties, obviously like we have multiple, let's say, agreements, like just to name a few, B2C operators enter into sportsbook agreements for the, like, I don't know, with sportsbook provider for the provision of trading services such as odds, live streaming services, sports statistics, casino agreements for the supply of casino games, gaming platform agreements for the provision of gaming platforms, payment agreements, marketing agreements, and so on. Obviously, like, it is important when it comes, let's say, to the choice of jurisdiction. This is also a clause. This is a clause that sometimes can be underestimated, because like parties may think that there are other provisions, other clauses in the agreement that are important, termination rights, financials, and sometimes they probably like underestimate the importance of this clause, or it's just like the box exercise and that's all. Instead, like it is really important to pay attention to this clause. First of all, because even if you think that other clauses are more important, if in any case a dispute will arise, like in connection with the contract, the court that will in any case decide on the case will give in an interpretation on such clauses.
Exactly.
So like that's why it is important to understand who eventually is going to decide
which
around
country,
which country, which court is going to decide like your in relation like to the contract. So here my suggestion first of all is to always align the choice of law with the choice of jurisdictions, not because the party may agree that, like, for example, this agreement is subject to Indian law and but select as like the forum, like the place of jurisdiction, courts of like Tokyo in Japan. But this means that like when like the courts in Tokyo needs to resolve a dispute in connection with the agreement, they need to apply Indian law, and obviously the interpretation of Indian law that like a court in Japan may have is totally different with the interpretation that an Indian court may have of like Indian laws, because they are very familiar, very much familiar now with their legal system. That's why my advice is always like to align choice of law with choice of with the place of jurisdiction. Then when selecting a jurisdiction, it's also important to be specific, because for example, if we want to use a I don't know, course like in the US, referring just to the US course like is not specific enough, no?
Yeah.
Because each state in the US has like its own legal system and so on. So also parties, if parties like refer just to the US course, obviously like this leaves room for interpretation, like leaves flexibility to the party to select then where to start the dispute. Same goes for the UK, no? Because that's why parties tend to specifically say that the courts of England and Wales have jurisdiction, because UK, also Scotland falls under UK, that has like a slightly different legal system. And that's why it is important to be very specific. And also when referring to a state, for example, Italy, Germany, to specifically indicate the forum. So it's going to be, for example, Italy, okay, but which forum? Rome, Milano, or like in Germany, which kind? And then it's also important to specifically like state if the choice of jurisdiction is exclusive or non-exclusive. No, exclusive, which means that in any case the parties are going to legally bound themselves like to start any dispute in that specific forum. Non-exclusive, like obviously the party, besides like starting let's say a dispute in that specific forum, they still have, let's say, the flexibility to start a dispute somewhere else. Sometimes we also see like cases of asymmetric, let's say, jurisdiction, let's say, clauses. This normally happens when there is, let's say, a party that has more negotiation power than the other. So like they tends to impose a specific place of jurisdiction to the other, but reserving the right for itself, like to start the dispute also somewhere else. No?
Yes.
So this is obviously like quite uncommon, but it may also happen.
And do you have a preference towards arbitration? Do you think it's more efficient, or
it can be more efficient or no? First of all, it depends where, because like in some countries arbitration can be effective, in other countries can be
the same as the court system.
Exactly, it cannot be like effective. In some countries can be very expensive, because like arbitration normally is a private like arbitration, so like it can be very expensive. So also this needs to be carefully, let's say, assessed. It's not just a tick the box exercise just to put something there, like that the party in any case will decide that like an arbitrator will decide rather than like going directly like to court. So also here it depends on the choice of law and the jurisdiction, and then yes, I may take, let's say, an approach or like another like approach depending on this.
And of course, whilst we're discussing contract law, we did mention disputes and litigation. In the gaming industry, is it leaning towards a more preemptive legal structuring, so ensuring that there are clauses to preempt any possible litigation, or is it reactive? And what is the strategy that you would sort of lean on?
In my opinion, is leaning towards like preemptive legal structuring.
Because it's obvious that I'd rather not litigate than actually litigate.
And especially I would say for large international, let's say, companies, traded, let's say, gambling groups, because also it's a matter of like reputational risk and regulatory, let's say, scrutiny, no?
Yes.
Because if in any case getting a fine and then challenge the fine, or like entering into, let's say, I don't know, multiple civil litigations, sometimes may have, let's say, a huge impact on, let's say, on reputation, and especially like for big operators that are licensed in multiple jurisdictions. Sometimes if you get a fine or you are like involved into a litigation in another jurisdiction, you need to report this also in the other jurisdiction where you carry out your operations. Or if you are apply for a new license in a specific market, sometimes as part of the regulatory scrutiny from the regulator, operators are asked to disclose, for example, fines that they got, litigations that they are part of, and this may lead to a rejection of the license application.
Yes.
That's why it is important for, let's say, well-established, like large group, large, let's say, international gaming groups to invest on legal compliance, the right tools in order, let's say, to prevent the their companies from entering into a litigation rather than challenging or facing litigations, So 100, in my opinion, is like this is like the trend.
Preemptive.
Yes, 100%.
That's the best strategy.
Yes.
I would tend to agree with that. Dario, we reached the end, and so a bit of a future outlook and strategy. And one final question: what's one legal trend that gaming companies can't afford to ignore in the next 1 to 3 years?
So, I would say mainly three. One is like responsible gaming, because we already mentioned responsible gaming, and I think that regulators and operators will keep focusing on, let's say, responsible gambling also in the next 2-3 years, for sure. But I would mention the use of virtual financial assets. So I think that like in the next 3 years, operator will start using also like cryptocurrency in some like for their gambling services, and the regulators will also start realizing the importance of regulating the use of virtual financial assets within the gambling, let's say, environment. And then I would say artificial intelligence.
Yes.
Because it's also this a trend that like operators cannot ignore in the next 3 years, because artificial intelligence can give us, first of all, is inevitable. Like we can avoid artificial intelligence. Can give us a great help also in our daily operations. Speaking about responsible gaming, also when it comes to prediction tools, like tools that can help us in detecting like signs of like problem gambling. And also what is important is that regulators and legislators are already realizing the importance of artificial intelligence in connection with the gambling industry. Just to mention one jurisdiction, Italy, last year the online sector was reorganized with the legislative decree 41 of 2024, and in Article 14, it is specifically mentioned the use of artificial intelligence by operators in order, let's say, to detect signs of gambling problems. So even regulators and legislators now are realizing the importance of artificial intelligence. That's why I think that is a trend that, like, a legal trend that
one
cannot be ignored.
Exactly.
Also, like we have seen also like the Artificial Intelligence Act at European level. So like also from a legal perspective now is like being, let's say, heavily regulated. So I think that definitely like these three are the trends that like an operator can ignore in the next 3 years.
Yeah, and I definitely agree with you. I mean, I've even started noticing that regulators are actually asking operators in various industries, not just gaming, what AI are they planning to use as part of their business strategy. So I agree with you that especially AI is something that one needs to start looking at and keeping abreast, especially from a legal and contractual point of view as well. Dario, thank you very much.
My pleasure.
Once again, it was really interesting. As always, time always runs out, but I'm sure we'll meet again for another episode. So thank you so much.
Thank you.